Good morning to you, and you are watching NTV. And welcome to our program this morning on making a case for protection of women's property and land rights in cohabitation. With the exception of the 1995 Constitution, the subordinate laws that regulate the distribution, management and ownership of property during marriage, upon divorce and death of a spouse are discriminatory for women. Even where the relevant statutory laws are protective of women's rights to property, their implementation is hindered by customary law practices, socialization, and the generally weak economic capacity of many women in the country. Now, despite Uganda's progressive legal efforts to establish gender equality in property rights, there still exists a large disconnect between land reform legislation and actual reforms in practice, particularly with respect to women's rights to own and inherit land and other assets. Now, the failure to effectively implement land reform in Uganda is in part due to the presence of legal pluralism in the country. Multiple misconceptions exist about women's rights and relation to land and property. And in making a case for our topical dialogue this morning, protection of women's property and land rights in cohabitation, FIDA Uganda and its partners, See Her Network and UN Women, hope to achieve the following at the end of this dialogue. One of the achievements is raising awareness on land and property rights in marriage and cohabitation in Uganda. The other objective we have this morning is a call to attention of the gaps in the law and policies in Uganda regarding women's land property rights and make recommendations, as well as building consciousness about the subject among different members of the public. Follow the conversation on the hashtag Family Law Reform Now on NTV across our social media platforms. We're also streaming live right now on our YouTube channel. My name is Priscilla Regina Naloga, your moderator this morning. Once again, welcome again to our dialogue campaign, making a case for protection of women's property and land rights in cohabitation. My guests this morning are none other than Susan Baluka, Strategic Litigation Advisor with FIDA Uganda. I'm also joined by Caro Idembe, who is a Team Leader, Policy Advocacy and Partnerships in Interreligious Council. We also do have an online engager from Nairobi, Kenya, and that is Nyokabi Njogu, who's the legal counsel, the Kenya Legal and Ethical Issues Network on HIV and AIDS. And so, without further ado, let me allow these ladies to have their voices heard as we get into the deep of the conversation. Starting with FIDA Uganda, represented by Susan. Good morning to you once again.
Good morning, Priscilla. Thank you very much for having us on this platform. I must say that I can't wait to delve into the discussion. As you rightly pointed out, the issue of protection for women's property rights, not just in marriage, but even in other family-forming unions like cohabitation relationships, is an issue that has really affected women greatly. It's an issue that we have grappled with as far back as the 80s or even before that. And I really believe that this conversation is timely, especially with recent discussion on the importance of protecting the family unit. I think this discussion is very timely. Thank you.
Right. And next to Susan, I'm joined by Caro Bunga Idembe, who is the Team Leader, Policy Advocacy and Partnerships with the Interreligious Council of Uganda. Good morning to you.
Good morning, viewers. I'm excited to be here to share and hold a conversation on cohabitation, because we know in our religious spaces that 70% of people who congregate in our churches and mosques are women. And so it's pertinent to be able to talk about these issues, because they are real issues, and we have the faces are the women. So thank you.
All right. And of course, from online, we do have the Kenya Legal and Ethical Issues Network on HIV Legal Counsel, and that is Nyokabi Njogu. Good morning to you, Njogu.
Good morning, colleagues, and thank you for having me on here today to talk about this very relevant issue. I'm looking forward to the discussion.
Okay, getting into it, of course, this program is part of a series of engagements FIDA, SIHA Network, and UN Women are undertaking in their recently launched campaign, the hashtag Family Law Reform Now, and we're encouraging you to follow FIDA at their social media platforms. Just type in FIDA_Uganda on Twitter and FIDA Uganda on Facebook to follow them and follow this dialogue. Now, starting with FIDA itself, Susan, when we talk about cohabitation, first of all, what do we define that as in Uganda today?
I think without even going into specifics of terminology and definition, let's just look at our society. We know so many people in our families, in our communities, our neighborhoods, who are living together as man and woman, and they have been that way, been living that way for years, 5 years, 10 years, 20 years, 40 years, and they are not legally married, or they are not in a legally recognized union under the laws of Uganda. So I think, just to put it simply, we have so many people we see in our communities that are living together as man and woman. They have raised children, they have created homes together, they have started businesses together. And put simply, when you look at that, you can ably say that these people are in a cohabitation relationship.
Okay.
Yes.
All right. Mr. Zidambe, looking at the statistics and also religion in reference to this conversation with the Interreligious Council being represented, looking at what was shared in statistics, the first statistics were captured in 2006, showing that women were cohabiting at 4%. The last statistic survey that was taken was in 2016, and that figure had risen to 30%. For the men, it seems to be moderate. Between 2006 and 2016, from 6% to 19%. This not negating the fact that religion considers a particular kind of marriage as legal in this conversation.
I think, truth be told, within our Ugandan laws, marriage is elaborately prescribed in our laws. Whether you're monogamous, customary, it is very clear. But for this particular relationship, everything is silent, and that silence is the epicenter of all these push factors and the violence and the discrimination. So as a religious body, first of all, it is in our interest to make sure that everybody is in a legal binding relationship. But unfortunately, it's not the reality. The reality is that people are cohabiting, and the numbers are many, like you have been able to share. But as an institution, we continue to encourage man and woman to make sure that they legalize. We know that part of the push factors have been the exorbitant funds sometimes that are asked by, if it is customary, it becomes very expensive.
The dowry prices.
The dowry prices, and you look at a young man who has just finished school, is the higher institution, and they don't have the money. So I think we need to get back to the drawing board as Ugandans. What do we want? Do we want property? Because even to get married, people want to exchange property. But as religious institutions, we are saying, let's look back. You can actually decide to walk in the church, in the mosque, as long as you've been able to fulfill the legal requirements of announcement, and actually wed you at the altar there. So it is a conversation that we need to candidly speak about it. And churches have, over time, encouraged massive weddings, so that it becomes also a little bit much easier in terms of handling the expenses. But of course, the root issue is the heart, because when it comes to cohabitation, of course, we'll later talk about property. There is no actual date when you say, we have now started
yeah.
cohabitation. So that is the dilemma of religious leaders. Because whereas when you get married, there is an official date when you get married. And even the government has a marriage certificate to know that these two people were able to start this journey on this such and such a day. So that vagueness of not even knowing when you started is what also incurs the religious leaders. Yes, okay. When did it begin? Because this one will say it is 10 years, the other one will say it's 5 years, the other. So there is no definition, definite definition when this cohabitation journey starts. And so that vagueness also brings in a lot of challenges, and of course, especially women are the ones to suffer most, because when it gets to the power relations, it's the men who always have the power. So it is consciously, since our majority of people who attend our churches and mosques are women, it is our interest actually to make sure that this 70% is in a secure relationship.
Okay.
It is protected, and so we'll be able to later to tell you what are our strategies when it comes to this kind of relationship.
Perhaps our neighbors in Kenya, and through the lenses of Jago this morning with the Kenya Legal and Ethics Issues Network, I know that you have been at the forefront of so many reports from Kenya on court decisions, property rights of cohabiting couples. What's the case, what's the environment, and what's perhaps the protection in terms of policies, regulations, and the law generally in regards to cohabitation?
Well, I'd say Kenya is like Uganda in the sense that the reality is that many people are engaged in cohabitation unions. So people come together as young as at university. That's where anecdotally or colloquially people really talk about it, that this is something that is happening. We do not have a legal framework for cohabitation. So while our Marriage Act does define what cohabitation is, and it says that it's a union that is akin to marriage, similar to marriage, we actually don't have a legal framework that protects parties within cohabitation unions. And now what happens is that at the point of one spouse wanting to pass a benefit to the other, for example, in the case of medical insurance, then parties are forced to maneuver to find ways to make their relationship more legal, so to speak. So they would get maybe an affidavit of marriage, or at the point of dissolution of a union, then now they come to say that, look, we were married and this is why I am deserving of a share of your property. Or in the unfortunate case of death, then now mainly women would have to come and say that they were actually married to the deceased, and they have photographs to demonstrate in court that they were actually deceased. And what courts have done is, over time, they've developed a test based on the Evidence Act, stating that, one, if there is a long period of cohabitation, so there's this quantitative element that we have lived together for a long number of years, and during that time that we lived together, people actually accepted us as man and wife, then they presume that you are actually married, and therefore they can now proceed to divide property, or whatever benefit is supposed to be there. But of course, this then now comes to the question of whether parties are actually able to prove this element of we're actually living together and we're intended to be husband and wife. And now what would happen is that sometimes in court, especially in division of property acquired during such a union, one of the parties, usually the man, could say that we were actually not married, we were just girlfriend or boyfriend, or even worse, they were working for me as a domestic worker. So yes, they lived in my house, but they had no interest in my property, so to speak. So this now creates a gap, because usually we know that it is women who find themselves in this situation, who are unable to prove the qualitative elements of who are actually husband and wife. And sometimes what courts would then say that is that because you've not been able to prove that you are husband and wife, then you are not entitled. And what this then does is that it continues to disenfranchise women from accessing property that many times they're even making a living on. while the Marriage Act has tried to sort of regulate marriage, we see that it has compounded the problem, because the Marriage Act says that any union you're supposed to register within a certain time frame within contracting it. So for even customary unions, it's supposed to be about 6 months. But now that element of, if you don't register, it's like now your union is just deemed as a mere cohabitation or as an unrecognized or unregistered union. And now the same problem arises either in case of succession or divorce. So courts are now being forced into this presumption element. And now where the presumption was not able to be met, then what would happen is that you are unable to access a share of property. This dispute found its way all the way to the Supreme Court. And now we have a certain framework that the Supreme Court has given guidance, one, by recognizing that the reality is that consenting adults will sometimes live together with no intention at all of being considered married. So cohabitation as a valid family forming union. And the court has given guidelines about how this should happen, but there's still lots more work to be done.
Thank you so much, Njogo. The element of presumption is really still unanswered, and as long as that exists for the courtroom, it's going to be very hard to make decisions. Yet, at the end of the day, we do have women that are not legally married continuing to suffer, and couples are living together, they're buying property together, they're investing together, but without getting married or without the registration, different forms of marriage registrations that do exist. It comes down to a rock and a hard place. So to you, Susan, in terms of FIDA, what are the issues that you and the partners are actually raising to seek protection for cohabiting couples?
Thank you very much, Priscilla. I think in relation to what Nyokabi has actually pointed out, the fact that just like Kenya, in Uganda we don't have a specific act of parliament, a law that has been passed by parliament that specifically recognizes cohabitation in their uniqueness, cohabitation relationships in their uniqueness. All the issues we are talking about of how do you determine when the cohabitation started, who is considered a cohabitee, if we are boyfriend and girlfriend but we are living in separate houses, is that cohabitation? Even though we actually have children, you know, between us, so many questions are raised, or so many what ifs are raised when you bring up the issue of cohabitation. And our first point of, or our response to that is what the importance of the law then would be, because a law then goes on to look at what is the reality of the society we are living in, and then elaborating on what ought to happen when different scenarios and circumstances arise in a particular situation. So that is the first thing. There is no law, and it is important because cohabitations exist, and they exist at a really high rate. Okay. Secondly, still in relation to the issue that Nyokabi pointed out about customary marriages, the most recent demographic health survey report of 2016 also highlights that actually, in terms of forms of marriage, customary marriage is the most common type of marriage in Uganda. However, luckily for us, in Uganda, unlike Kenya, it is not mandatory that your customary marriage must be registered in order for it to be legally recognized.
Which then also becomes a loophole in the system.
I would say that it serves as a double-edged sword.
Locally is that perhaps the cultural centers that we have, for example, you do have the Uganda, they do register and recognize that marriage. You do have the artists, so they will, register and recognize those marriages. But what else?
No, but Susan,
exists?
You need actually to register that customary marriage at the sub-county chief. Although it will not nullify it, but it's a good practice that actually it is entered into the local government records. Yeah.
Yes, and that is accurate, but I think the point of departure between Uganda and Kenya is that, unlike Kenya, if you don't register it at the office of the CAO, who is the registrar of marriages in every district, then it will not be invalidated, which is the case for Kenya. If you don't register it with what you call the equivalent of a cow or register of marriages in your district, then it will not be recognized. Here, if you don't do it, it will still be, you know, recognized as long as you can prove. So for instance, like you pointed out, the certificates people get from the Uganda Kingdom on Kwanjulas, or from the Atesot cultural leaders, you know, will help with, you know, proving that, you know, actually what
parents signed, you know, acknowledging that my daughter has been given in hand of marriage to this family.
Exactly. Even photographic evidence is permissible in court if you want to prove a customary marriage, and that is great. However, on the flip side, where those things don't happen. So for instance, the way Carol raised the point of resources, there were no resources to do a big traditional ceremony with photographic evidence and all those other certificates from the cultural institutions. Where someone says, you know what, we just picked a date, we went to the elders, they told me I should, by word of mouth, they told me I should present 5 goats. I presented them and we were married, right? Where a person fails to prove that those things actually happened, then even when they did in fact happen, they are going to find themselves in the same predicament as someone in a cohabitation relationship where no steps were taken to actually contract even a customary marriage. So that is also something that we should think about.
Okay. Going back to you, Mrs. Idembe, in regards to the subject matter, I guess the core of this is the legality. As long as there's no legality foundation, then all the conversations that we're having are going to be blown into the wind. Let's look at the marriage and divorce bill. It has been in Parliament. It has gotten dusted again, undusted.
Renamed,
and yet the purpose
names
of this bill, among others, is to reform and consolidate the law relating to marriage, separation, divorce, and also provide for types of recognizable marriages here in Uganda. It's also supposed to look into the marital rights. It's supposed to look into the marital duties. It's supposed to recognize cohabitation in relation to the property rights. But to date, it's not being attended to. So in the absenteeism of this bill and this act, where do we stand?
First of all, there is an attempt to, when you get to clause 115, up to 20, it speaks about property rights. But majorly it speaks about spouses, and then all of a sudden, boo, it talks about those who are cohabiting. And it's like it is from the moon, it has dropped somewhere, but it doesn't have roots. So in the wisdom of religious leaders, they went by the way, clause by clause. And they were very pertinent to have that fairness, but they realized that this clause is only speaking about property rights of the cohabitees, but it's not giving any other solution. So in the wisdom of the religious leaders, said, since government has the mandate, a constitutional mandate, is it possible for government to actually have a separate legislation and have a candid conversation with the people who cohabit, so that it's not only on property, but even the other issues that pertain to this particular relationship? Because they have children, they have now property, a lot is around there, but the law doesn't cover them. So since the state has that mandate, the religious leaders said, when it comes to that area, we will not actually contribute, but we request the government to speak to the people themselves, so that there is a very condensed legislation that deals with all their issues, but not only on property. Because you solve one property issue and then another issue will come in. So why don't they look at them as Ugandans and then come up with the legislation? Otherwise, when you look at the marriage bill, it's not only talking about property, and yet these people live as if they are married. So it is a recommendation by religious leaders that let them have a very comprehensive bill, because they were saying this is a competition, you know, you're competing, you want people to get married, so we should not be again the advocates of saying you cohabit. But the state, since they have the constitutional mandate,
right,
they should be able to cater for the interests of these Ugandans.
Okay. Let's engage Njogu in this regard. With what you have heard, Njogu, in Kenya, is there a huge disconnect between land reform legislation as well as actual reforms in practice for you there, in particular with respect to women's rights to own as well as inherit land and perhaps other assets? Of course, in line with the fact that there's a lot of legal pluralism that exists in this conversation.
Yes, indeed. Well, on paper, Kenya has a very vibrant legal legislative framework for the protection of the rights of women to own and access land. But now what is missing is that there's this disconnect, particularly within the area of family law. So through our constitution, women can, of course, own land. Practices that are supposed to, that usually disenfranchise women are prohibited. We have a very strong equality clause in our constitution. Protection of the family is even there in Article 45. And unfortunately, the courts have now said that the protection of the family does not extend to meaning that women have equal rights to property that is acquired, that people would still need to demonstrate how they actually acquired this property, which is why I'm talking about while women are allowed to own. Yes, you can own, you can buy, but if it is acquired within the framework of family law, of the family rather, then women now have to assert what their contribution has been so that they can now be able to access that property. And now this disconnect is seen most primarily within the relationship within the family, because again, in a legal a country where that is legal pluralism, and on top of that we are very patriarchal in nature, women are usually relegated to perform certain duties that do not necessarily mean actual monetary, you know, they can't be quantified in monetary terms. So when you're coming to the point where you're trying to assert your right to own a certain kind of property, then that, of course, can be a challenge for you, because what it means is that you would then only be allowed to access a lower threshold, or to, you know, your rights are lower because you've not been able to actually state what your contribution is or to prove what your contribution is. While our Matrimonial Property Act does talk about the need for unpaid or domestic care to be taken into account, what then happens is that it's difficult to quantify. In the context of a cohabitation relationship, where the matrimonial property laws will not apply, because what our Supreme Court has said is that parties should then divide that property under the framework of ordinary property law. So how does a woman in a cohabiting relationship, prove that she actually performed certain forms of unpaid care? And then what is the value of this care, so that she's able then to access property that was acquired within that domestic relationship? So there's a huge disconnect, and this is why family law reform remains a very pertinent issue to ensure that discrimination of women is done away with, because despite having a progressive legal framework, we are still in reality seeing that without substantive equality, without reading the law in a gender transformative way, then women continue to be disenfranchised, and it's really vulnerable women who have a challenge in terms of proving what their property can be. Kellen has tried to educate women around registration of marriages, but what we are seeing is that For whatever reason, people don't want to be in marital unions, and that's okay. And the courts have said that this is okay. But there's still a significant gap about how women are going to access property on a basis of substantive equality with the men in those kind of unions.
Matrimonial Property Act, and of course she's spoken immediately into the pluralism that exists now. For those of you who don't know what it is, it's really the coexistence and interaction of statutory laws with multiple legal orders such as state, customary, could be religion, project and local laws, all of which provide basis for claiming property rights. But as long as there's no particular act that actually mentions and defines cohabitation and what should be in there to protect women in terms of property rights, then it goes a long way. The hashtag is family law reform now across our social media platforms. Just type in NTV Uganda, but equally Fida_Uganda on Twitter and Fida Uganda on Facebook to engage in this dialogue. You can also stream live on our YouTube channel NTV Uganda. Now, turning to the Interreligious Council, why don't you just encourage people to get married? Because at least there's protection there of women in terms of property ownership, and in case of divorce, separation, there's a more legal foundation of protection for the woman. So let's just encourage them to get married.
I think for me, I want to speak about pillars in this country that have tried it. In the era when we had HIV/AIDS at its peak, the Archbishop Stephen Kazimba, when he was the Bishop of Mityana, actually encouraged many people to wed. Because remember, with the HIV/AIDS and then the property issues, once you died or your spouse died, it was another thing altogether. And so he has done it. Of course, now he's an Archbishop. We have encouraged him to continue with that conversation. But me and my spouse, we are married in Ivukula, we used to do it. It's recently when we said, but with the COVID, we stopped. But we would have 50 to 100 couples get married. Our contribution would be for, you know, when a woman puts on a white gown, it is a very special event, so would partner with those who have the gowns, pay for them, and then would ask, communally, everybody contributes to the meat and the rice, and then the church, St. John Church in Ivukula, Archdeacon, who would be able to hold the marriages. And I want to actually, not proudly, but I think I've seen the benefit of it. Less of the conflicts, because at least now people are in that legal union. It's something I think we need to rekindle again, because I know even with marriage there are issues, but at least if there are issues, there is a legal way to be able to solve it. So it is something that I think we need to continue with that campaign. But in case it doesn't work out, the state needs to find a solution for these people, because it's not only on property, but there are many other numerous issues that need to be solved.
Susan, you seem to be shaking your head, disagreeing with Carol. Why do you seem to be disagreeing with Carol? Because if there's protection there, then I guess it's the right thing to do in the meantime as we wait for a proper legal framework. Or are you saying that there are other, you know, legalities and maybe in the courts of Uganda, judgments that have been passed upon which they can consider basis of protection, or in terms of property and rights when people who are cohabiting separate?
Okay, so I'm not disagreeing with Carol. I agree people should be encouraged as much as possible to get into a legal regime that can, you know, protect them at the moment. However, even with the encouragement that the religious leaders have been doing, I'm sure even in so many other churches, people continue to encourage people to get married. I continue to see mass weddings, even to this day. Even the Uganda Registration Services Bureau is doing a lot to encourage people to undergo civil marriages. It will cost you not more than 350,000 Uganda shillings on average to get into a legally recognized civil marriage in this country. And I have seen the Uganda Registration Services Bureau, you know, making effort to sensitize the public about that. And I am sure very many people actually know about it, at least a considerable number of them. But it still goes back to the question of, so if there are all these cheaper alternatives as to why, rather cheaper ways in which people can actually enter into legally recognized marriages, why are the numbers of people who are cohabiting still high anyway? And it is not...
well, I'll give you one reason. It's an increasing population. So if you have an increased population, expectedly, you will be having an increase in number cohabiting.
But let me just
But
give
that
you
shouldn't
this.
be an excuse, nevertheless.
No, it's not the only one. I will tell you right now that I know at least 10 people who are lawyers and they know the law, good lawyers, and they have been in cohabitation relationships for 5 or more so years, right? I mean, the reasons...
do they acknowledge between themselves that it's cohabiting?
I think the point is that you may never really complete the list of reasons as to why people don't actually get into legally recognized relationships. And those reasons are largely influenced by the fact that a relationship, whether it is a relationship of boyfriend and girlfriend, or a relationship of fiancé, fiancée, or a relationship of husband and wife, it is a social relationship. It is not like a business transaction which is going to be governed by logic and rationality. It is a relationship that is governed by human need and human emotion. And therefore, the question of why don't you just get married and get into a regime that will protect your interests legally ignores the fact that family relationships, by their nature, are social interactions, social human interactions. And just like Carol said, if for one reason X or the other, which we may never complete that list of reasons, people don't get into that legally recognized marriage, and the statistics are there, that this is a common kind of relationship in society, the state has an obligation to put in place a law, and this is very important, to put in place a law, I beg your pardon, that will give protections to people who are most vulnerable when that relationship ends. It is not just about getting property.
All right. So while that's a good consideration that you're putting forth, then it negates what the Interreligious Council is trying to, push for. Just let's get people married. Let's get people in an official arrangement that is recognizable by the law and the state. With this consideration, it's then opening up cans of worms for the Interreligious Council, because people will then be asking myself, I'll be asking myself, now why should I go through the hula bala of a wedding, the cost, and when I can simply say, sign here and sign here, we legally agree that we are cohabiting, and whatever the case be. But let me turn to Njogu in Kenya. There's been a recent social media outbreak on a football player who plays for PSG and also from Moroccan descent. He's called Ashraf Hakimi. He most recently his wife took him to court. Divorce settlement comes through, and at that stage they realized that the man is broke. Not that he's broke, but he was smart enough to register his property under the mom, giving her legal custody over everything that he owns, which means that the wife then walks away with nothing. But there was an altercation to it that then, because it's a separation between the two, then whoever has property in that legal entity that property should be divided in two, shared by the two, and then the divorce is concluded. Perhaps there's so many other cases of that nature. From that point of view, where is the protection of women in terms of family law reforms?
So, the case of that footballer was, it's also a topic of discussion here in Nairobi. And I'm sure many places. But I think it just points to the intricacies of the vulnerability of women, especially where they are not, what we consider the actual income earners. And I think the call should be to protect all forms of family forming unions. And while recognizing or appreciating the role that the religious sector has to play and every other thing, I think it's also important to recognize, like Susan has said, marriage is a social cultural issue, and people enter into marriages for very different reasons. And it's for those very same reasons that people may choose not to enter into a marriage. But I think what the state then needs to do is ensure there's protection of all forms of family forming unions. And where a spouse is going to such significant lengths to hide property from a spouse, that's already a failing on the state. It's the fact that there has been some form of union means that the state must provide protection for women, because what happens if you don't provide that protection is that women will continue to be left out in terms of property ownership. For vulnerable women, especially here in Kenya, the statistics are that while women spend most of their lives making their living on land, only 5% of them actually have title to that property. And what happens if a woman doesn't have access to title or access, they can't use it for getting collateral, collateral to get loans from financial institutions. They can't use it for anything really. So you're there at the behest of your spouse. And if your spouse wakes up and decides that it's time for you to go, or brings in another party to that union, then what does that happen to you, the vulnerable woman who might not be able to know that you actually have recourse in law? And it's not just about property, it's also about protection of women upon death of a spouse, because that's another aspect that comes to it. If that footballer had died, what would happen to his wife if she wakes up and she finds herself with no protection, no source of income? What happens to her and her children? So it's not just about, this trope that has been painted around a woman who wants to grab property upon divorce, but it's also about providing lifelong protection to this woman who has decided to change her life to be in a union with this other party. So I think I'm with Susan when I say that while the religious sector can do what it can, not everybody is going to be able to register or going to want to register a marriage under the law as we know, as the religious council may want it. And that's just the reality. So bearing in mind that reality, the state needs to step in and provide some form of protection. And one of the protection in this ways for all forms of family forming unions is to ensure that there is now a law, a statute that says that in interdependent cohabitation relationships or other interdependent relationships, then this is how you would divide the property. And when I say on a basis of substantive equality, what I mean is that it takes into account all forms of contribution of each of the parties before it proceeds to divide the property. So that's one way. And the reason I'm saying that the religious way is not necessarily the only way to go is because of the Kenyan experiences. For a long time, we worked with widows who were disenfranchised at the height of the HIV pandemic, who were thrown out of their homes, who were accused of all manner of things and disinherited. We still engage in mediation on behalf of these widows, or facilitate mediation through the Council of Elders, but it's not enough because these cases continue to come over. If registration of marriage was the tell-all or the solution to all of these problems, then we wouldn't be having this conversation today. In Kenya, our Marriage Act is actually 9 years old now. Presumption of marriage has been in existence since the 70s. Registration of marriages has been tried to be accelerated by the state as well as by religion, even through the local administration for 9 years now. But this is not ending. So it's a point to a significant gap that courts have said that the gap is there. There's a need for recognition of this kind of interdependent relationships. to ensure that you don't have also situations where spouses are hiding property, or in the unfortunate event of death, that a widow will not, or a person will not find themselves kicked out because they're not a widow as under what the law provides for is a widow.
Thank you so much, Njogu, for that submission. With your legal counsel, of course, she's stating that ensuring there's a statute on interdependent relationships, taking into account all forms of contribution. Now, as we wait for the state to actually give us a statute to protect what this conversation is all about, FIDA Uganda is doing something about it. So moving forward, what are the proposals that you have on table so as to mitigate making a case for protection of women's property as well as land rights in the cohabitation scene?
Thank you. I think one of the most important things, first and foremost, is for the state to acknowledge that this is a need. Acknowledgement is important, and also to appreciate that in as much as we live in multicultural, multi-religious, and we have different standards for what may be right and what may be wrong, it is important to look ultimately at the most vulnerable people. In this case, being women who are disproportionately affected, as it has been reiterated over and over again. So it's important to have in place a law, a statute that clearly provides for rights of people in cohabitation relationships. And it is timely, given that we have now the marriage bill, which Honorable Sarah Opendi proposed should be retabled. She made that proposition, moved that motion in 2022, last year. So I think it is important that Parliament should also appreciate the fact that in the same light and in the same vein, they should also now table a bill on cohabitation relationships and unions and have it in place. But in addition to that, I think it is also important for government, specifically the Uganda Bureau of Statistics, to examine this issue further. You know, the statistics that they have should not even just go beyond what is the percentage of people in cohabitation relationships. They can still go as far as looking at what are the gender implications of there being no legal protections for people in cohabitation relationships.
Okay. I would speculate that the reason as to why this bill has not seen the signature of the president is simply because of conflict of interest. While we want to believe that there's legal marriages, there's the religion bar upon which so many decisions are made, undermining the originality of countries and continents such as Africa, and our traditions and our customs are being put to bed in light of religion, which is causing a lot of conflict. Therefore would be the indecision of government on the matter. Mrs. Idembe, in conclusion.
I think in conclusion, I want to say, before the advent of the missionaries coming in the 18th century in this country, we had our culture institutions, and they were very strong on their traditional marriages.
Very true.
So
and they even had proper methodologies of doing it. Your family will get the man of this house, unite them with the woman of the other house, mutual family agreement.
So there was a value system,
and they were solid,
which we want to uphold the traditional institutions, but also for the religious institutions, we are encouraging many people to get into this legal arrangement in your churches, in your mosques, even the registrar of marriages. Please, you go there. I have gone a number of times in the Uganda Registration Bureau, and I have seen Eritreans, Ethiopians actually get married every day. But rarely do we see Ugandans marching there. So I think we are giving excuses on that matter. I will encourage as many people to get married, talk to your priest, talk to your imam or sheikh, so that this matter is settled. But even customary, it is potentially polygamous, but at least there is a legal cover under you. So I want to submit that we encourage you. But in case you are found in that relationship of cohabitation, let's reduce when it comes to property to at least an agreement. I encourage women and men to have
because even just land, land exchange. They you write something and people sign those existing
because I want to give I'm a lawyer and I have practiced for many years, but we made a decision with my spouse whether I have bought property or not. My name is there and his name is there, and that is enough protection. We don't want to argue over that. But I had to do also my legal awareness. So even in the communities, if I go to educate people, you can't afford to be bringing your man and somebody reduces it in their names only, and yet you have brought your contribution. So there are small steps which we need to encourage people.
All right, let me allow Susan to have the final word. You have 30 seconds to do that.
Thank you very much. I want to reiterate, just also in response to what Carol has pointed out, I think it is important for us to appreciate and for government to appreciate the fact that ultimately the person that needs to be protected is the most vulnerable person. The most vulnerable person in this scenario of cohabitation that we are talking about is a woman who is not educated, who because of historical discrimination on the basis of sex and gender has never gone to school, does not understand a word of what even an agreement means, and is therefore was raised to understand that as a woman her role is to be a homemaker.
Okay.
Thank you.
All right. Well, it's been an interesting conversation, opened up a can of worms. But again, the point is to make a case, right? And we have opened up that case with a campaign that FIDA Uganda is holding, and we are hoping that we have built some form of consciousness about the subject amongst different castes within the public at the end of this dialogue. I've been joined by Susan Baluka, Strategic Litigation Advisor with FIDA Uganda. Thank you so much. And then Madam Carol Bunga Idembe, thank you so much for your advice on the matter. Team Leader, Policy Advocacy and Partnerships, Interreligious Council. And of course, for our neighbors, Kenya, we have had Njogo Njokabi joining us with your legal counsel, the Kenya Legal and Ethical Issues Network on HIV and AIDS. Thank you so much for the work you do. And we have to go. Time is first spent, but these conversations are going to be ongoing on social media, and so just type in FIDA Uganda and you'll be following up on the different elements of the campaign until something concrete is done about it. My name is Priscilla Regina Naloga. Good afternoon.